let's see. All right, well, we'll start off with the roll call.
Mr. Culver?
Here.
Mr. Bailey?
Here.
Ms. Blodgett?
And now introduction of city staff.
Mark Boyce, Chief Building Official.
Kim Flaherty, Project Manager.
John Cecil, Building Rehabilitation Inspector.
All right. We need approval of the minutes from January 20th, 2026.
Second.
All in favor? Aye.
Aye.
All right, let's get right to it. Case A, BP 2023-0026, 830 Berkshire Road, appeal of notice of condemnation and demolition order.
You can go over there, but I don't know if I'll be up or not, we'll see. But, Mr. Chair, I guess y'all do want me to be mic, so I guess, well, I have my mic here. Mr. Chair and members of the board, this one's a little different. Anthony Jackson, attorney for the city. This case is a little different than what you typically see. Here you have an appeal. And typically what your we have an appeal procedure pursuant to both the International Property Maintenance Code, the Land Development Code, as well as your rules and regulations. And that provides a process that includes a final decision to be made by the board, and once that decision is made, for action to be taken by the city. A final decision in this case, this is not a new case. This is a case that came before you. A final decision was made back in September of 2025. And that final decision included an order that said for certain acts to take place, and after those acts take place, for there to be a, if they fail to do what the order required, that they would be authorized to move forward with demolition. And so staff, based on that order, determined that the actions required by the board had not taken place, moved forward by notice that they would be moving forward for demolition. There was a email notification that's in your file. That was pretty absolutely clear that the board was moving forward and that there were all rights of review have expired, and there was nothing else that could be done in terms of
The March 18th,
prohibiting.
March 18th, 2026 email from Kim.
Yes. And so, but in addition to that email, there was a letter which was pretty much more of a form standard letter, and in that letter, the letter included language related to a right of appeal. Unintentional, quite based on history, but nevertheless it said it. And based on that information, the applicant asked to have an appeal, which of course the position of the city at that time and still is that they've exhausted all rights of appeal. Nevertheless, the ultimate decision, we believe, should be a decision of the board. And so we, in response to actions taken by the council for the applicant, we ultimately agreed to put it back on the agenda for the board to make a decision, one, whether you wanted to hear the appeal. I think you have a written appeal from the applicant himself. And if you did want to hear a further appeal, if you wanted to take any new or additional action. Now, interestingly, if I couldn't say based on the records that's been presented, the applicant asked for a very narrow appeal. The applicant asked for more time to be able to complete a sale. Said he had 2 pending sales and he asked for the time to complete them. That time actually has passed because of our need to delay, or our election to delay actually I said election, but our need to delay the proceeding at the request of the applicant. So at this time, the city maintains its position that everything is expired. There's no real authority from the city's perspective, other than we respect the power and authority of the board and whatever board's council would recommend to them. But the city's position is that based upon the city's land development code, based upon the International Property Maintenance Code, based upon Florida statute, based upon the board's own rules and regulations, this case is over. And that's our presentation for the day, unless you have more.
Chairman, can I ask a couple questions? Can I ask a couple questions? Yeah. Okay. So we had an order, and typically this board will have an order saying, okay, we uphold the finding of condemnation, we give the property owner a certain period of time to take corrective action, and if they don't, I think it's pretty standard that our order says the city may proceed with demolition, as that order back in September 2025 says. So and I think you're talking about this notice of condemnation and demolition order dated March 6, 2026, that does have the right to appeal in it. Would this be when an order is issued, like the one in September is issued, and they don't comply with that order, property owner doesn't comply, so the city is going to proceed with demolition, would this be the typical order or notice sent out to any property owner that's gone through the process? Is this the typical order we would normally send that would also include the right to appeal in it before the city demolished? Is that just a procedural thing?
Yeah, Mr. Simpson, my time with the board is about both of our times haven't been very long. Yours has been longer than mine. But I'm sure the board would already know that answer probably from what they've seen, but if I can have our staff sworn and they can answer that question. And let's tell the truth, the whole truth, nothing but the truth, so help you God.
You do. So the notice and order that you're questioning right now, right after we gave notice to the property owner that all times have expired, we were proceeding with demolition, title work was done, because he had mentioned in the past he was trying to sell it. When we notified this, he wanted time to try to sell the property. We had advised, no, all your time is done, we're tearing it down. With that information, we did a title search on the property to make sure we had the right owners, or he was still the owner prior to demolishing it. I didn't want a change of ownership without notice. When that title search came back, we discovered he had 2 mortgages on the property. Still his ownership in the LLC, but 2 mortgages. So by law, I needed to notify the mortgage companies. So that March 26th notice of condemnation was to the mortgage holders of
March
the
6th.
property.
March 6th one? Is what you
Yes,
did?
yeah. So those were to the lenders.
Oh, these were to the lenders?
Yes.
Okay. Not to the property owner?
No, we had already given him notice. He had made his appeal. We had the order.
Right.
It was the follow-up title work after being put on notice he was trying to sell the property that we
Okay.
determined there were mortgage holders that needed to be notified as well.
And we've had no follow-up notification from the mortgage company,
None.
so they have not asked for
Or
an
appeal.
appeal.
So like, if I can ask one question, when you have, like in this case, the order that was done back in September, it wasn't complied with, therefore you have the authorization from this board to go forward with demolition. Is there any further notice that's given to the property owner typically that we're proceeding with demolition, or do y'all just proceed with demolition?
Generally, we aren't required to, but I send an email, like the one that I had done prior, saying, putting him on notice, you've exhausted all time periods, you failed to comply.
Okay.
We are hereby proceeding.
So we could call that a courtesy note.
Yes,
So this notice, the March 6, 2026 notice of condemnation demolition order, which contained the right to appeal, was not sent to the property owner, it was sent to the mortgage holders.
Correct.
And the mortgage holders have not exercised any right to appeal.
correct.
That's correct.
No other questions. Sorry, take your time.
That's quite all right. And I guess it's time for council?
Yeah, sir.
My turn?
Yes, Mr. Moore.
Thank you, Mr. Jackson. God bless you. I'm Michael Moore. I'm here I'm with Moore-Lex. I'm here on behalf of 53 Nave LLC and Ezra Safdia. Mr. Safdia had filed this appeal, and I wanted to point out that that I have provided you with a copy of his appeal application, and it only differs from what you might have received from the city, so far as I'm aware, in that I've added Bates numbers in the lower left-hand corner of the pages so that I could direct your attention to those documents more easily. So if I could initially direct your attention to page 009, which is the demolition order that Ms. Flaherty just testified about in response to some questions from Mr. Jackson. If I could direct your attention to the last paragraph on page 009, talks about right of appeal, and it says, any person directly affected by this order shall have the right of appeal to the city's Board of Building Codes. So the city's Board of Building Codes would be your board, and one of the persons who is directly affected is Mr. Safdia and his company, 53 Nave LLC, which is the owner of the property. I want to point out two, and so we're going to work backwards a little bit. I want to point out and direct your attention now to page 8, that's 008, and paragraphs numbered 3 and 4. Paragraph 3 says that the structure is so deteriorated and neglected that it or a portion of it is likely or partially to completely collapse or to become detached or dislodged. Paragraph 4, it says the structure is clearly unsafe for its use and occupancy. Well, that's not the finding of the building official. And I'm now going to take, and I think this was boilerplate demolition order, as Ms. Flaherty testified, sent out to the mortgagees without any consideration of what I'm going to show you now. If I take you back now to page 12 is your order of appeal that was dated September 19, 2025. And in paragraph 2, it has 4 numbered provisions. The third numbered provision is actually numbered 3 twice. I think that's just a typo. But if we start off with the first condition under paragraph number 2, it says the board ordered the following action to be taken by the appellant. Schedule an interior inspection with the chief building official and building rehabilitation inspector no later than October 31, 2025. They did that. And that was done on October 24th, 2025. And the building official, that's Mr. Urquhart, said that it was a safe structure. And so I don't understand why why this particular property owner is now caught in this circular fashion of demolition and condemnation orders, which fail to consider that inspection conducted by the chief building official. So the facts, there have been some intervening facts that are different than what you've heard. It's not accurate to say that nothing was complied with and nothing was done. It further requires obtain a building permit for all work to be done on and in the structure no later than October 31, 2025. Now, he was working, and his appeal documents this, and he tells you candidly that he was working with Keystone Permits to get a permit, and they dropped the ball. I believe they're out of business now. And he was also working with a contractor that you may be familiar with, and I'll mention them again, that at the time had come under some scrutiny, and they had some serious issues going on that distracted from the work of contracting. All right, and so if we fast forward to today, that same contractor has obtained a building permit. We believe that the city of Daytona Beach has issued a permit to Daytona Construction Remodeling for this property and this work. And so he's asked you to do a couple of things, and I'm asking you to consider one, what he would ask you to do is to give him a couple of months or through the end of August, say September 1st, to sell the property. And I would ask you to also rescind or dismiss the demolition order based on the findings of the building official from October 24th, 2025. Mr. Safdia understands that there may be one or more liens. He's asked to satisfy one of those liens in the amount of $12,000. He's asked that you release the lien, and he doesn't, I don't know if there is a lien for $15,000, but he has the understanding that there may be another lien for $15,000. At any rate, he would ask that you accept his that the city accept the $12,000 payment in satisfaction of the $12,000 lien and release the second lien if there is one. He would request also that the city rescind or the BP designation as blighted property because that interferes with his ability to sell the property. And then additionally, if the board will not rescind or dismiss the demolition order, that they allow him to obtain a building permit by June 30th, and then give him 120 days after that to obtain a final inspection of the roof replacement and ground stabilization, and then obtain an inspection for rough-end work on the structure 180 days after the date of the permit issuance. Do you have any questions?
I thought you said your client already had a permit.
He does right now.
So what permit does he need to be issued by June 30th?
Uh,
I think Ken wants to talk.
Exactly. No. That's exactly right. He's already complied with that. But here's why I'm asking for additional time. This contractor, this is Daytona Construction Rehabilitation. They've had some challenges, and they went into the city and got a permit. The city, and it's our understanding that the city has issued a permit for this project, and we want to move forward. They asked us for a contract. We sent them 2 weeks ago, we sent them a commercially reasonable contract with a draw schedule on it. They couldn't commit to that, and we're waiting for them to either respond or give us some sort of response. And they haven't given us a response. So if they don't, it's possible that they could back out, and we would have to find another contractor to get a permit. That's why I asked for that amount of time. And I didn't specify that previously. I noticed that Mr. Safdia is on Zoom. Mr. Safdia, is there anything that you would like to add?
Yeah. There's for the most part, Mr. Moore represented what's needed. In simple fashion, really what I'm asking for, there's one thing that he did leave out, which is that during the last order, I ended up, once Keystone Permits was not able to procure a permit, I was in financial hardship at the same time. That's why in my second appeal here, I asked to just sell it. That's really what I'm asking for here, because I did go back to Daytona Construction Remodeling, and because I have a large construction holdback with my lender, and they said we can use that. It's more than enough money what you have with your lender. It's over $110,000. We can use that. We know your project backwards and forwards. We can fix it. We'll send you a contract. They sent me a contract in late March of 2026. It was, to me, a joke of a contract. I showed it to Michael Moore. We came back. We said, listen, we can't work with this. We got to use our own. They said, okay, fine, no problem. We sent them a contract that Mr. Moore worked on, much better than what they sent us. And they said, okay, we'll get back to you. And we used my scope of work, which they have had for 2 months, as Exhibit A, and said, you have to follow this scope of work. This is the money you have for each part of the construction. They said, yes, we know that, no problem. They didn't end up signing it. And then a few days ago, they came back and they're like, listen, we like the project. We still want to do it. But, you know, can you come back with more reasonable numbers for the amount of money allotted? If you know about the amount of money that's used for this project, I have for this project with my lender, 2 months. So obviously they're not serious. So that the permit that they got and they got approved for, they still ended up being used. In my original second appeal in March, I asked to just sell it. The only thing that changed differently in that appeal, I also said I couldn't have financial hardship. So the reason I called it doing construction and remodeling the second time is because I said, you know what, have a large construction holdback. They know the project. If they can use construction holdback to complete the project because the contract pricing will work. They said, yes, we can do it. A few days before, they said, no, it's not enough money. So that's not going to work. What I want is to be able to sell it. I got a second home enforcement lien. That's really for the same things the first one is for. For instance, I can pay the first home enforcement lien. It's my original purchase of this property. There was $12,000 held back from the seller. And I called my title company, Landing Title, and they can release $12,000 to pay the lien to the city. So instead of the city spending money to demolish the property, you can receive money for the first full lien. But in order to do that, I'm going to ask them to take off the second lien that was just placed for $15,000. That's essentially placed for the same thing. So what I want is to be able to sell the property without any liens, without blighted property status. And that can be done because the first lien can be paid via the $12,000 escrow Landing Title. The second lien for $15,000, which is brand new, which is really for the same thing that the first one is for, can be removed by the city as well as blighted property status. If the second lien and the blighted property is removed, we can pay the first lien via the escrow title company. And I really want 5 months to sell it without any of these liens on it. And let's let a new investor who has the means to come in and fix it. I don't see why the city needs to spend $30,000 to demolish the house when they know that it's safe, take it away, and they can get paid $12,000 for the escrow that's just sitting there, release the second lien, release the blighted property, and somebody else will go buy this house and go fix it. Somebody that's in a better position than me at this point. And that's really it. That's what I want. So I want time to sell it. I want second lien taken off and the blighted property status taken off. In exchange, I will give the money from my title company that's being just held there. It's just sitting there, and it's going to sit there forever. By the way, if it's not paid, the $12,000 is there for the time that I bought it. It will just sit there. So I want time. I will offer you to pay off the first lien. I want the second lien removed and the blighted property. And on top of that, the city knows that the structure is safe. There's no reason for this house to go from an as-is value of about $110,000, $120,000 down to about $20,000 if they knock it down. It doesn't need to be that. Some other investor will buy this for $100,000. And then I could just get rid of it at that point. I have two lenders. Yes, there is a second lien at mine, a second mortgage lien. James Goldberg, he's a personal friend of mine. He will move his lien to another property that I have without an issue to get rid of this. And then my first lien will be satisfied via the sale. I don't see why the city can't wait 4 or 5 months to see if somebody else comes forward to go do that. As opposed to spending money and then the lot will just sit empty until property values go up by enough money where it makes sense, which could be 20 years, or something like that.
Well, first off,
The difference this time around is there's money sitting in escrow that can be paid the first lien. I just want the second lien, which is essentially a carbon copy of the first lien, to be dismissed and blighted property status. And the city can receive money for this.
Listen, your connection's very bad, and they can barely hear you. And And so the chairman, Mr. Bailey, was about to respond. So please, sir.
Thank you. First off, we're not code enforcement. Code enforcement liens are not the purvey of this board. Any reduction or whatever has to be taken up with them. Also, you know, whether there's a first, a second, a third, or a fourth lien on the property also is not under the purvey of this board. What is the condemnation order that was issued last year, and the conditions were not met. Now, I understand you want to sell the property. I see 2 contracts which are not executed. I only see buyer initials on these. So basically, it doesn't really mean anything. My personal opinion is to uphold the original order. And I would like to hear from my board members on their thoughts.
Well, I agree. I think it's based on long enough, and this was ordered to be condemned, and it was appealed, and it was not, it was upheld recently or earlier, so I think we should, I agree with you, is to uphold the demolition order.
And if I could, and that's true, knowing that the building official did the inspection you asked the property owner to do, came back and said it was a safe structure. Doesn't that expose you to your decision-making?
Kim?
All right.
Clarity, permits and licensing. Glenn did go out and inspect the structure. He came back and gave a report. It wasn't determined that it was safe. I can show you pictures from a couple weeks ago, or absolutely, it's not safe. He said you could continue with permitting the next step to make it a safe, habitable structure. At that time, he did not rescind his position on the property. He simply did an inspection to address with the owner and his contractors what needed to be addressed on the permitting to rehabilitate the structure.
Do you have the information regarding a subsequent permit?
I see where Keystone did apply for a permit, but it is not a valid permit at this time, which is why my courtesy notice was sent to the property owner that he had failed to meet all order requirements.
Okay, and Keystone was on the original, that was in response to the original order on appeal, 012. But how about as of right now?
I did not see one. Let me pull it up again.
It's not from Keystone, it'll be from Daytona
I'm
Construction.
going to pull up.
And board, I'm just, for the sake of validation, I think y'all have expressed with the opinion of the board, but just for the sake of validating for Mr. Moore's sake.
There has been nothing submitted in 2026.
He checked, Mr. Safdie, did you check this morning and you saw that Daytona Construction had been issued a permit?
I'm live on the Daytona.
Yeah,
website.
I have March 27, 2026. There's something stamp permit number 407-285. Jessica Ogden, license number CRC 1334745. It's a request for a permit extension, and it's issued.
What was the R number?
R2407-285.
That's a 2024 permit.
Yes, sealed from the city of Daytona Beach.
That would have been from the contractor you previously, before your first appeal. There's nothing submitted,
Yeah.
and we would not open a 2024 permit. You'd have to meet the new codes. Nothing has been submitted for 2026.
It says to the top left corner, I'm looking at the page right now, and I texted it to Michael. It's in Michael's phone as well. March 27, 2026, extension granted for 90 days. Michael, check your phone. Do you have the PDF?
I can't understand what you're saying.
He said he texted you what he's looking at to your
Okay,
phone,
okay.
to see if you can pull it up.
All right, let's see.
I have it, Glenn Urquhart signed a 90-day extension for a 2024 permit that had already been closed by the contractor. that you brought in, said you weren't even working with anymore.
So, what they did, or what it appears they did, was they refiled the application for R24, R2407285. It was received March 27, 2026. And
They extended a closed permit though, so I'm not sure how that happened. When he already had a new permit with Keystone that was expiring,
so it's
or
like
expired.
the reason for the extension, homeowner canceled the project originally because of unforeseen circumstances. Homeowner would like to restart the project. And so that's with Daytona Construction and Remodeling. So,
But I think he just testified there's no contract with these people to proceed at this time.
so I sent him a contract. We're negotiating one.
Okay, so I guess
And
this,
he's testified that he has sufficient amount of funds to contract with them. The contract, and we just found out that they didn't like our draw schedule 2 days ago.
okay, well, there's a two-part thing going on here. I mean, in one sense, I hear Mr. Moore, and I hear it more so a request for how administratively the city's willing to deal with his client, but also know that we're here to determine what this board action is going to be as relates to this. And the board has made a final determination back in September, put in place an order that it expressed. By the admission of the applicant himself, the order was not sufficiently satisfied. And as a result, he is in non-compliance with the board's order, which results in the city being authorized to move forward with demolition. If they want to fight with city administration, they can fight all day with city administration. It doesn't really have anything to do with this board's, if the board makes an ultimate decision to say that you're upholding your previous order. There was some indication that maybe the desire of the board, I know you didn't take a formal vote, but just from the expressions of the board, if that's the decision that we're seeking.
So I understand that's what they're seeking. It just seems to be an administrative convenience that they're trying to destroy a structure that doesn't need to be destroyed. And when the property owner has the funds and the willingness to rehabilitate it, and he's had some trouble with some problematic contractors, and he's trying to iron out his exposure to any sort of bad business, and do his due diligence, and he's asked you to reconsider. And this is a property that has value. He's previously submitted appraisals, and the city is aware of that. And so we would ask you again to reconsider your demolition order. Thank you.
And no disrespect to Mr. Moore, he said that the applicant has the funds. I think the applicant is repeatedly, both in writing as well as his testimony, saying as far as rehabilitating the structure, that he doesn't have the funds, and his goal is solely to sell the structure to get whatever money's necessary.
That's not accurate. That's not accurate. He just testified that he had $114,000 in construction holdback funds from his lender. That's what he would use to fund it.
Can I speak?
Go
Can I
ahead.
speak? Okay. Just so everyone understands, the $114,000 is in a construction holdback, so the lender holds that back, and as work is done, they release the money. Okay? I am in financial hardship right now, so I can't rehabilitate it on my own. However, I know that, like Mr. Moore said, the structure has value, so I can sell it probably $110,000 or $100,000. Yes, I have 2 mortgage liens on it. First one is for under $100,000. Second one is for more than 110 I mentioned. However, that person is a personal friend of mine, and he will move that lien off. Okay? In addition, I have $12,000 sitting with my title company, land and title company, that can be used to pay off a first code enforcement lien. So I know you guys are not code enforcement, but the structure, in my opinion, and as seen by the construction official, is not on the verge of collapsing. It's not, it may be habitable, but it's not on the verge of collapsing. Somebody else can step in and sell this. What I'm asking for is time to sell this. And I will offer, the $12,000 with my title company, pay off first lien, the second lien, and related property taxes will be taken off. That's all I want. I want time to sell it to somebody else who can step in and do it. And my mortgages will not get in the way of the sale. It has enough value to cover the first one, and the second one will move. So I just want time to sell it.
We don't have
The city
anything
knows
further,
it
Mr.
doesn't-
Chairman.
The city knows it's not on the verge. The city knows it's not on the verge of collapse. They went inside and they saw it. It's in no way on the verge of collapse.
We can sympathize with your client's plight, but, basically asking for more time to sell is only going to push it off into somebody else. We're going to have the exact same problem 90 days from now or whatever. And, at some point in time, and this is not a new issue, this has been on for a couple of years. And again, this, my personal opinion is, we are going to uphold the condemnation order.
Okay, so when you say that in 90 days it's going to be the same thing, it's not, because you're going to be dealing with a different investor who's going to come in and
We would be dealing with a different investor with probably the exact same problem that we have right now today.
I don't understand. That's completely unreasonable. Different investors, a different person. So that's, I've been in a very different life situation that's going to want to buy it to make the money. So to say that I'm going to be, the next person's going to be like me is completely unreasonable and not true.
Not really. I deal with this type of thing every single day in my work day, as does Jessica.
Not everybody's the
And
same.
Paul, for that matter.
That's not reasonable and not true. So you don't know who the next person's going to be, and we're going to have better meetings. We can submit proof of funds and so on. This person is not me, and that's clear as day. I mean, it's, well, I want time to find that person. If you want to knock it down later because I can't find the person, you guys will have more than enough power to do that. There's no need to go knock it down right now when you already know the structure has value. Just give it some time, let somebody else step in, and
Your
do
time
the
is up,
project.
sir.
And if they fail, you'll knock it down on them. I'm no longer in a position to be able to fix this, not right now.
Yeah, his time is up. I believe, is that unanimous?
Yeah.
There needs to be a motion and a second and a vote.
Right. And then motion to uphold the demolition
I'm
order?
gonna make a motion to uphold the motion.
You have a second? We'll do a vote?
And just clarify, you said uphold the motion,
Uphold.
uphold the order.
Yeah, uphold the
Uphold the order.
the original demolition order from September 2025, yes. All in favor?
Aye.
Aye. Motion's unanimous.
We don't have any other cases to bring before you.
Yep. No other cases? This meeting is adjourned. 9:42.
Mr. Chair, thank you very much.
Thank you.
Oh, thank you. Thank you, Mr. Moore.
Thank you, Mr.
Thank you for
Fletcher.
coming.